community supervision with your attorney. Did you understand it?
Yes, ma'am.
Are you the same David Romero who's placed on community supervision in 2025 CR 002660
Yes.
for the offense of possession of a controlled substance? All right, this motion to revoke, let's go off record. Yes.
Okay. We would like to orally amend it to be possession of a controlled substance, P2, I believe it was 4 to 200.
All right, PG1.
PG1.
All right. Any objection to the amendment?
No, Judge.
All right. Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same David Romero who's placed on community supervision in 2025 CR 002660 for the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams? Is that you?
Yes.
All right, state.
Violated condition number 47 on or about the 10th day of October 2025 in Bexar County, Texas. The defendant David Romero did then and there fail to register and complete the GPS program in violation of condition number 47.
How do you plead to that? True or not true?
Mm.
All right, you seem unsure.
When I got out, I did. They take me to put
We'll,
it down here.
we'll explain it to him.
All right, so is it true or not true? All right.
State will waive the remaining.
Any objections?
No, Judge.
Did you understand by pleading true to violation of condition number 47, the court could find it true, grant the motion, and sentence you up to 4 years in the prison?
Yes.
Knowing that, do you still wish to plead true to violation of 47?
Yes.
Court will find 47 true. Is there a proposed agreement?
There is not, Your Honor. The state would be asking that you grant state's motion, revoke, and sentence him to 4 years in the prison based on the fact that this is not his first MTR, and he has shown that he is not complying with probation as he agrees to.
All right. Defense?
Judge, the history of this case is that he was arrested December 4th last year. He stayed in custody till sometime after July 1st of this year. He was granted probation in April of this year, but it was awaiting a tap in custody. Somehow he picked up a misdemeanor in July. You brought him back in on a motion to revoke in August, and then he had a hearing in September where you denied the motion and continued him because he had pled out, I think, because he had time served on the misdemeanor already. He was given the work release GPS, and he got his GPS on.
Right out of the gate, this is serious. A motion to revoke community supervision means probation is on the line in places like Bexar County. Once the state files this motion, the judge can send someone straight to prison if a violation is proven, even if it's not a brand new felony. And notice how calm this sounds. That's how revocations work. Quiet, procedural, but potentially life-changing.
But when he went to work, his boss told him, you can't be having that on the people, the customers, they'll get worried. So he got concerned and he tampered with it. He took it off. But he did email his officer pictures of where he was, including the address, the street, told them what the situation was. But of course, he got violated anyway. So he spent most of the last year in custody, including since October now. So he's, the probation department was recommending ISF, cognitive track. He was okay with that, and then the state decided they would rather recommend the revocation 4 years. So he'd prefer the cognitive track, but he'll obviously leave it to your discretion.
All right. So you can't tamper with GPS. That's the number one thing you cannot do, and this is not your first motion to revoke. Based upon your plea of true, the court is going to find violation of condition number 47 true. The court will grant the motion, revoke. The court will sentence you to 4 years in the prison. You'll receive credit for all the time that you've been in custody. And the court will suggest the therapeutic community. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it? All right, you do have a right to appeal. That right to appeal is as it relates to the allegations in the motion. not the fact that you are on community supervision. Do you understand? All right, good luck to you, okay? Okay. Are they? All right, so have you all reached an
That hesitation that's the moment, because when he says truth he's not just admitting a mistake, he is giving the judge legal grounds to revoke probation immediately. In Texas revocation hearings, the burden of proof is lower than a criminal trial. No jury, just the judge. Would you have pled true here or forced the state to prove it?
agreement or this is going to be a jury trial?
This is going to be a jury trial, Your Honor.
All right, how long do you expect this trial to last?
We expect this to last between 4 and 5 days, Judge.
All right, Ms. Ferguson, no later than March for a jury trial date?
March 10th, Judge.
All right, you'll come back on March 10th. At that time, you will have your jury trial. Once you
Okay,
sign
Your Honor.
the form, you're excused. Yes?
Your Honor, we do have one more matter. At Mr. Vaquera's last status conference, you indicated that you would rule on a GPS matter that we have filed with the court to put Mr. Vaquera on tracking only. We're asking this specifically because Mr. Vaquera's wife is pregnant and is due any day now, and we would like for him to be able to be at the birth of his child, but also to be able to help coordinate care for his child with his wife.
All right, with regards to GPS, the defendant is allowed to attend. I'm sorry? Yes.
Would be in opposition to tracking only. I am fine with it remaining as a partial GPS with the condition that he can attend the delivery of life baby and be allowed to attend ultrasound.
All right, the court is going to allow you to attend any and all medical appointments. If there's an issue, just let your attorney know and they'll let me know.
Your Honor, may I speak for myself?
Yes.
The reason I would request for tracking only is because, like, I have my wife and I have my very pregnant wife who is sitting over there. She is due in literally 10 days from now. Our 1-year anniversary is tomorrow. We like, all of our stuff is in 2 separate households. I would like to be able to go see her. Logistically, it would be impossible to move everything in one household. So I would like to be able to spend some time with my newborn son.
Or as that goes, make arrangements, the court's approval, no objection.
All right, he can attend any and all medical appointments. If there's something else outside of that, defense, you'll need to come to court and be in person in court. And you need to have it set anytime before December 18th.
Okay, we can do that, Judge.
All right, thank you. Once you sign the reset form, you're excused.
So that
Thank you, Your Honor.
splitting time between.
You'll have to talk with your attorney. So far, what I've approved is any and all medical.
And there it is spelled out up to 4 years. This is what probationers often underestimate. A technical violation like GPS tampering can unlock the full underlying sentence. It's not about the new conduct being a felony. It's about violating trust. The judge is basically asking, do you understand? I can max you out right now.
Appointments. If you want something beyond that, your attorney will need to request to have that matter placed on the docket. They'll need to be here in person at 9 a.m.
We'll get it set, Mr.
That
Vaquera.
needs to
Just send
be
the
done.
reset. We'll give you a call.
And that needs to be done before December 19th. Otherwise, it's not going to get done until the new year.
We understand, Judge.
All right, thank you.
Thank you, ma'am. I appreciate
Your
it.
attorney, did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment and the information?
I do, Your Honor.
State, are you proceeding on the indictment and information as presented?
In the clause ending in 01, state moves to waive the enhancement allegation, but other than that, yes.
Any objection to the waiver of enhancement?
No objection, Your Honor.
And cause number ending in 52, did you review the waiver, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
By entering into a plea in this cause number, you're giving up the right to have a grand jury hear the evidence in this case, and also the right for your attorney to have 2 days pass from the presentation of the information and 10 days to prepare for trial. Did you understand?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this cause number?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. In each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Your Honor.
And the cause number ending in 01, you're charged with unlawful possession of a firearm by a felon as a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. And cause number 52, you're charged with evading arrest or detention as a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
And each of the cause numbers, if you have a plea, the court does not have to follow your plea. If for any reason the
No agreement. That's huge when there's no negotiated deal. Sentencing is completely in the judge's hands, and the prosecutor just highlighted something critical: not his first enter, meaning not true revocation before repeat violations dramatically shrink judicial patience. At this point, the tone shifts from second chance to consequences.
court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering these pleas, you're giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Thank you,
Counsel,
Your
in each
Honor.
of the cause, you're welcome. Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, to the extent any of us are.
Mr. Knowles, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter into the pleas?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
In each cause number, the cases will run concurrently. This will also run concurrently with 2019 CR 2606. They'll take into consideration 2025 CR 001300, County Court cause number 724788. And in cause number ending 52, that's restitution to Daniel Garcia. Your punishment is to be assessed at 2 years in the state jail facility, and there's a $1,200 fine and no applications. And the cause number ending in 01, punishment is to be assessed at 8 years in the prison. There's a $1,200 fine and no applications. Did you understand that to be the plea in each of the cause numbers?
Yes, Your Honor.
Defense is at the plea.
That is, Your Honor.
State,
Yes, Your Honor.
did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there many such motions?
There are not, Your Honor.
Then in cause number 2025 CR 001301, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And the cause number 2025 CR 015652, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any.
And just like that, 4 years, notice how fast that happened. No dramatic music, no shouting, just a measured ruling. This is how revocations often get clinical and final. The only small relief credit for time served. But hey, race, the bigger question: should removing a GPS for work, even if reported, equal 4 years, or is this exactly how accountability is supposed to work?
Evidence.
Plead offer State's Exhibit 1 and all attachments in both causes.
No objections, Your Honor.
In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. For the defense?
Kurt Hopke.
All right. And are you Mr. Favela?
Yes, ma'am.
Counsel, have you received all discovery?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Favela, did you review the true bill of indictment with your attorney? Did you understand it?
I did.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Favela, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
I did.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I did.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Absolutely.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is.
Mr. Favela, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
I am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
I do.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the document, the plea bargain page with your attorney? Did you review that? According to the plea, state is asking that your punishment be assessed at 63 days in the Bexar County Jail under 1244, $800 fine, and there are no applications. Did you understand that to be the plea? Defense, is that the plea?
Yes, it is.
State, is that the plea?
Yes, Your Honor. Also, on there should have been taken into consideration cause number 2026.
I'm sorry, what's the cause number?
2025 CR 010700.
No objection, Judge.
Thank you. Did you review the document entitled Waiver of Appeal with your attorney? Did you understand it and sign it in both places?
Ma'am.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions? Mr. Hopke, have there been any such motions?
No, Judge.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Okay.
State any evidence.
Proceed off for State's Exhibit 1 and all attachments.
No objection, Judge.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand that the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Ma'am.
Court will find.
And this is the side of the bench people don't always see after imposing prison time. The judge pivots to something deeper: addiction. The final warning, it's blunt because it's REA.
That defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. Court has reviewed the same. The court is finding there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, please.
All right. The court will follow your agreement, sentence you to 63 days in the Bexar County Jail under 1244, give you credit for any time served. There is an $800 fine, time and money to run concurrent. Court will take in consideration 2025 CR 010700. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you will need to speak to an attorney. Do you understand?
I do.
All right, we can go off the record. Here's the thing. You obviously have a major drug problem. If you do not get help for your drug problem, what's going to end up happening, you're either going to be in prison or either somebody's going to have to identify your body. When you're released from custody, if you can't find a sober living home or a transitional home, I'm still here. Come back here and I'll pick up the phone and call somebody to help you. You understand?
Appreciate that.
All right, good luck to you.
Thank you.